Hi, this is Jim Cunningham. We're going to talk about trusts unpacked, revocable versus irrevocable trust. Very common question. A lot of people want to know the difference between revocable and irrevocable or irrevocable. And lawyers will stress that. By the way, when you hear lawyers talk about this, they'll say revocable and irrevocable or revocable and irrevocable, just so you can hear the difference because that little IR at the beginning really changes the way these trusts are looked at by courts and lawyers. So a revocable trust allows you to maintain control over whatever goes into this trust during your lifetime. You can amend the trust, you can revoke the trust. You can put in a living trust, and we'll talk about that. You set up this trust for yourself while you're alive, and then after you die, other people take over and get what you leave behind on this earth. That is how a revocable trust works. An irrevocable trust can provide greater tax benefits, can provide creditor protection. A revocable living trust ultimately will become an irrevocable trust, and we'll talk about that, why that sounds like it might not make sense, but why it does make sense and why it happens. And we'll find out which options best align for you and in your individual situation. So the idea here is to educate you a little bit, as well as hopefully entertain a little bit. If you're watching this on YouTube, we do these sort of natively in a webinar format. People can ask questions. If you're watching this on YouTube, please post your questions. If you're watching this on YouTube, you will see a list of types of trusts. We're going to go over these. These are trusts they range from the living trust to the an AB trust. We'll talk about that. Pet trust, special needs trust, domestic asset protection trust, generation skipping, Clayton, IRA trust, dynasty, charitable trusts, and a bunch of other, basically alphabet soup of other types of trust acronyms. Those have to do with tax planning, trusts, and creditor protection. So I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've been a lawyer for over 30 years. I'm a certified specialist in estate planning, trust, and probate law. And I'm a real estate broker, insurance, and securities licensed, and a pilot single engine land instrument rated, although I am not current. So very broad background. This is a disclaimer. This is very important. I'm a lawyer. I'm talking. We're going to go over a lot of information rather quickly at a fairly brisk pace. This is very important. If I say you, if I'm looking and it looks like I'm looking at you, there's no attorney-client relationship. This is very important. This is information only, and you should get legal advice from a real human being, not some AI bot or a video, but you should get it from a real human being. And yes, I am a real human being, and we have human beings that work here at our firm. Well, let's start with the revocable trust, what we call the revocable living trust. I think a lot of people have heard of this, kind of have a general idea of what it is, but I'm going to walk you through just the nomenclature, trustee, what a trustee is and what a grantor is, and also a little bit how this works. So I would say for most of our clients that become estate planning clients of our firm, we're helping them with a revocable living trust. So this is really the cornerstone of modern estate planning. Certainly in California, if you own real estate, you're going to want to be looking at a living trust. Whether you do it or not is a different question, but I would say 99% of the time that is the recommendation. Now, what is a trust? A living trust is like a bucket. So it's obviously a document, but it's a bucket with a handle. And into this bucket, you put your house, your stocks, your bonds, your mutual funds, maybe your rentals. We'll talk about that. Certainly LLC interests that you might have. So if you have a rental inside of an LLC, you would put the shares of that LLC into your living trust. Your IRAs, 401ks, annuities, life insurance, those stay outside of the trust. Those pass by beneficiary designation. So this living trust, while it's yours, you're holding the handle, you're a trustee. You're the beneficiary. You're getting the goods, the benes, the Latin word meaning good. You're getting the goods in the trust, and while you're alive, you're holding on to this handle as trustee. When you die or when you become mentally incapacitated or resign, that bucket passes to another person, and that person who's named the successor trustee. So if I have a living trust and I'm holding onto my bucket, and I name my wife as my successor trustee, when I die, she becomes trustee. She's no longer known as successor trustee. She drops that modifier to the term trustee, and she is now simply the trustee. So she's holding onto the bucket. She's administering that the assets in that trust, maybe for herself. It might be for her and our children together. It just depends on how the trust is written. But what this does is it avoids probate, and we'll talk about why that's a good idea. There are some little used strategies. I would say they aren't used enough with estate planning lawyers. A lot of estate planning attorneys are very concerned about avoiding probate and sort of this orderly transfer of wealth. Many estate planning attorneys, and I think it's unfortunate for clients, aren't thinking enough about creditor protection. I know that when my wife and I leave this earth and our children inherit what they're going to inherit, I'm really concerned about that going to a future ex-son-in-law or future ex-daughter-in-law. So there are ways you can write your trust to make sure that the future exes of your kids, if you will, don't necessarily end up with that property. So that's very important. That's something we really pay attention to in our firm. And again, not many firms pay attention to that. A revocable trust, now if it's a single person, when that person dies, a revocable trust becomes irrevocable at that person's death. So the revocable trust becomes irrevocable at the person's death. That means nobody can amend the trust. You can't revoke it. You can't amend it. The question is, how do you dissolve it, right? We're going to talk about that because that's a little bit different than amending or revoking the trust. But it's very important to understand that a living trust can be amended during the person's lifetime. That's one of the hallmarks of a revocable trust. A trust is presumed, if the trust doesn't say if it's revocable or irrevocable under California law, the presumption is that it is revocable. How do you amend a trust? How do you change a trust? You have to do it in the manner provided in the trust. If the trust is not sufficiently specific, then you have to do it according to California law. That's a recent case. So here's kind of an example of a basic sort of estate plan. We have Abel and Baker Smith. They create the Abel and Baker Smith trust dated June 19th, 2025, which is the date we're recording this, which happens to be Juneteenth, which of course is the day that the Emancipation Proclamation was read to the last people who were held in bondage under slavery. And this is a trust that says Abel and Baker Smith are put their assets. Remember this trust bucket we talked about with the handle. Abel and Baker are holding the trust bucket. And into this bucket, they put their house, their stocks, their bonds, their mutual funds, IRAs, 401ks, life insurance, stay outside. When Baker dies, when Baker is the first spouse to die, there is something called trust administration. Now, this is very, very important. These assets will if you're a California resident and community property, these assets acquire a adjusted basis, meaning with a revocable trust, and this is one of the great benefits of a revocable trust, those assets get a full adjusted cost basis. So if Abel and Baker bought their home for $1 million or for $100,000 and it's now worth $1 million, Baker dies, Abel can sell that home for $1 million and not pay capital gains tax. It's very, very important. So that's part of what we're talking about, valuing the assets, removing Baker's name from the property. You might have to record deeds at the county recorder. So there is work to be done. Then Abel inherits everything. Everything's just kind of held in trust for Abel's lifetime until Abel passes away. And then when Abel passes away, again, those assets get another adjusted cost basis. So if that $1 million house went to $1.5 million, the kids could sell that house, or the trustee of Abel's trust could sell that house for $1.5 million and pay no capital gains tax. If you have $10 million in Apple stock that you got for $100,000, same rule. The survivor can sell that stock free of capital gains tax. So this applies to all assets, does not apply to annuities. This is very important. Does not apply to annuities, does not apply to IRAs, 401ks, 403bs, TSAs. When the children inherit, they can inherit outright, meaning Abel and Baker, they pass away, they leave it all to their three children equally. And now that inheritance that the children receive, it is, if they're married under California law, they're separate property. I'm assuming the children live in California, but it can become community property. And this is what I mentioned earlier with when a child inherits, how do you keep that inheritance from potentially becoming community property and subject to a divorce if one of Abel and Baker's children gets divorced after inheriting? Well, what we use is we use something called the Inheritance Protection Trust. So that is a trust where the assets, the inheritance does not go into the child's name individually. It goes into a trust. The child can be the trustee of that trust, and there's some certain safeguards we put in there, but certainly the child could be the trustee of the trust, or if the child's irresponsible or a minor, someone else is trustee of the trust. But my point is, those assets are not just simply stuffed into the pockets of each child. These go into a trust that gives that child a certain degree of creditor protection. And most of our clients want that. Why is probate bad in California? We cover this in other webinars. It's a 16 to 24 month process. It is very expensive. It is 4 to 8% minimum. It can be as high as 100% of the value of the estate. And we'll have an example why. Also, living trusts are fundamentally a private, a confidential process, if you will. It is not disclosed to the world. Certainly the people who are named in the trust or the people who would inherit if there were no trust do have the opportunity to investigate or to see the contents of the trust. But it is not something that is in the public record. It's not something that's filed in the court system. A will is a public record. Anyone can walk up to the window, find out what this will says. You know, if I die and I die with a will-based plan, anyone can see what I'm inheriting. Anyone can see what my kids are inheriting, the dollar amount, when they inherit it, their address, a whole bunch of information. And we live in this, it's a very antiquated system. But in this modern era we live in, I would not want that information in the public domain because it will be there forever. So probate can lead up to 100% of the value of the estate because the probate fees are based on the fair market value of the property. For example, if a person dies with $1 million house with a $950,000 mortgage, the probate fees are about $50,000. It's going to take the equity away. So that was an example of where they could be 100%. So again, here's an example of $1 million estate, $46,000 in fees plus maybe $4,000 in costs. The executor gets $23,000. The attorney gets $23,000 on $1 million estate. So how do living trusts provide peace of mind? A living trust is a legally binding document that clearly outlines your wishes. This is the revocable trust. Knowing that your directives are legally enforceable provides confidence, right, that your intentions will be protected and followed. So when you leave this earth, you leave everything that you have behind, and you are in the United States, you do have the power to leave your property to whomever you want. Okay, so there's no forced inheritance. You don't have to leave it to some to spouses, some to children. It's the way many, in fact, most other countries are. The United States does not follow that example. So this having a written estate plan, having a properly written and funded revocable living trust really reduces or minimizes the possibility of misunderstandings or disputes. Now, if you have a living trust, there can be a dispute, but sometimes there's a dispute because people don't know what mom or dad wanted to do. So having it written down, having it stated, I think can help. Knowing that your affairs are in order gives you peace of mind, right? It gives you control over your future. It gives you agency. You are deciding what happens with your stuff when you're gone and who's in control, and that helps peace of mind. Now, we have an example here of Drew. He has a living trust, and he says, look, half of my estate's going to go to Ellis, who took care of me in my final years. Maybe Drew doesn't have any children. And the other 50%, so 25% each, go to Frankie and Gray. It's very clear. So 50% goes to this person, 25% goes to that person, 25% goes to that person. And this minimizes disputes, because if there is nothing in writing and Drew and Ellis said, well, hey, Frankie and Gray, Drew wanted to give me half and wanted to give you guys quarters, that's something that should be written down for obvious reasons, because Drew's not around to say otherwise. Now, here's what's really cool about a living trust. So let's go with this example of Drew. Drew can change his mind. So you set up a living trust. It's kind of like wet concrete, right? And you can move this concrete around until you die, then it becomes cured and you can't do anything with it. But while you're alive, you can change it. So Drew's living trust says 50% of my estate goes to Ellis, who's taking care of Drew. But Ellis says, Drew, I'm tired of taking care of you. I'm going to go travel. Drew says, okay, then I'll just leave it equally between you, Frankie, and Gray. Drew can change the estate plan through an amendment or a restatement. An amendment, you heard that, because a revocable trust is amendable. Drew can amend his trust to change the disposition of the assets. It's very important to understand with an irrevocable trust, and this is why we, generally speaking, do not use irrevocable trust for the foundational plan, if you will, sort of the baseline core plan, is most people want to have the ability to change who gets what, is the bottom line. And with a revocable trust, you can do that on your own if you're the person who created that revocable trust. You can amend or revoke that trust. Now, the Tax Cuts and Jobs Act, which was passed in 2017, that expires at the end of 2025. So we're in 2025, and the president's big, beautiful bill, as it's being called, has not yet passed. And you may be watching this, it might have already passed. You might be watching this at a different time, and it never did pass. I have no idea what's going to happen because we're recording this on June 19th of 2025. But under current law, that Tax Cuts and Jobs Act is going to sunset. and the federal estate tax exemption is going to get cut from about 14 million. Really, it's 13.99 million. I don't know why the government just didn't round up for 14 million. Drives everyone nuts. It's going to get cut in half. This $7 million exemption is adjusted for inflation, so we're anticipating it to be around 7.2 million if the legislation is not extended. The big beautiful bill is, as it's called, wants to kick that up to 15 million and index it to inflation. So it sort of sweetens the pot for people with larger estates. What about irrevocable trusts? Again, I mentioned your revocable trust can have some irrevocable surprises. So it's like, it's like Cracker Jacks. You get a secret toy surprise in the pack, but you may not like it. Okay. What is an AB trust? An AB trust is a type of living trust. It is a living trust that married people created quite often before 2011. So before 2011, we had when I started practicing law in the 1990s, the federal estate tax exemption was a puny $600,000, right? $600,000 was the amount that you could leave free of federal estate tax. And then if you had more than 600,000, it was taxed between 37 and 55% of everything over 600,000. Very, very, very punitive, frankly, tax bill. Certainly with today's numbers, I think people are, broadly speaking, wealthier than they were 30 years ago when I started practicing law. That those numbers, my gosh, I mean, would be very high, would be millions of dollars for many, many people. So an AB trust was a type of revocable trust that was used, that married couples used, so that each married couple had 600,000. But here's the problem. If I'm married and I die and my wife inherits my 600,000 and she already has her 600,000. Now she has 1.2 million. When she dies, she only has a $600,000 exemption, right? So that her 600,000 is taxed at 37 to 55%, and that was 235,000. An AB trust says, when Jim dies, my half of the property goes into a B trust, a bypass trust. And you can also think of this as the buried spouse trust or the below ground spouse trust. So this is how lawyers remember it. The B trust is the buried or below ground spouse trust, which would be me dying, my wife surviving. She's in the A trust. She's the alive spouse. She is the above ground spouse. Here's the deal. The A trust, the survivor's trust, is a revocable trust. It still remains revocable, meaning that when the surviving spouse dies, so that spouse who has the A trust dies, those assets in that A trust get an adjusted cost basis. I mentioned that earlier. So meaning those assets, maybe they were bought them for 200,000 and they're worth 600,000 now. So when the heirs inherit from my wife, who is the beneficiary of the A trust, remember I've already died, the kids get to sell those assets free of tax. The assets that went into the B trust, here's the problem. So I die 10 years later, my wife dies. I'm the first spouse to die. My assets go into the B trust. Those assets may go in at a $600,000 value, but when my wife dies and the kids inherit that $600,000 asset, it's worth $4 million. This is not uncommon. Okay, we see this frequently if there's been maybe 20 years. The kids are going to pay capital gains tax on that difference between $4 million and 600,000. So they're going to have a capital gains tax bill on $3.4 million, which is about $1 million. Okay, that is the fundamental problem with the B trust. Is there is embedded capital gain. So if this is you. If you're thinking, wow, this is, when dad died 20 years ago, I remember mom had one of these AB trusts and their assets in that B trust, those do not get a step up in basis. They don't get an adjusted cost basis. And that can really be very taxing when it comes to finally dissolving both the A and the B trust when mom and dad or your parents pass away. It may not be your mom and dad. It could be step parents. It could be any kind of combination, right? In modern America. But my point is, if you have married people, one died and there's an AB trust and there's a survivor, while that survivor's alive, this is very, very important. While that survivor's alive, there are some steps that you can take to unwind that B trust, okay? There's some steps you can take to make sure that those B trust assets get a step up in basis. It may require a court order, but we do cover that in other webinars. This is a Clayton election trust. So we talked about AB trust. It means on the death of one spouse, the surviving spouse gets half, the buried spouse, the below ground spouse goes into this separate trust. This is a slide. If you're watching this is something called a Clayton election. I would say this is a very sophisticated strategy that when one spouse passes away, people with a larger estate, maybe a couple with a $20 million estate, maybe even a younger couple with a $10 million estate, if they're worried that their assets are going to grow beyond the estate tax exemption, which is currently $14 million, a lot of people look at this, okay? And all this is a slightly more convoluted way of funding or creating this B trust, this bypass trust for federal estate tax purposes, this bypass trust to reduce overall death taxes. I'm not going to get in the weeds on this, but this is something that certainly is out there. A Clayton election trust does involve two irrevocable trusts. One is the marital trust, also known as a Q-tip trust, which we'll talk about, as well as the family trust or bypass trust, the B trust. So we're going to talk a little bit more about these later. So a revocable living trust with no AB provisions avoids probate, allows you to manage assets if you're incapacitated. It's private. I would say this is the foundational document for most estate plans. So what has happened since 2011 is the estate tax exemptions went to $5 million. Now they're at $14 million. Most people don't have a $14 million estate. If you're married, you can double up to $28 million using portability, which we cover in another webinar. It's where you file a document with the federal government after the death of a spouse. It's very important to do, frankly, if you've lost a spouse. But where I'm going with this is this revocable trust avoids probate, helps you manage assets if you're incapacitated. But for the vast majority of people, I think it's 99.9% of people in the United States, having an AB trust to save federal estate tax is no longer necessary. And it comes with this trade-off to avoid federal estate tax. You end up subjecting some of these assets to capital gains tax. And it's simply, when you do the math, for most people, it's not worth it. AB trust, I would say if you want to control where if you're the first spouse to die and you want to control where those assets ultimately go after your surviving spouse dies, you're going to look at an AB trust. You might look at an AC trust, which you get a step up in basis. All you mean is you don't have the negative capital gains tax issues that you do with the B trust. But I think it's something to look at if you have a larger estate. But for most people who have an AB trust, they don't need it. ABC trust with Clayton election, I would say, would be the preferred method for larger estates. It is very flexible. This has to be in the original trust. You can't add this after somebody dies, by the way. This has to be in the trust document while both people are alive. And this is a very common tool. Again, I think this is something that's beyond the scope of just identifying that the Clayton Trust involves irrevocable trust. That's kind of the point I want to make with this, but we can certainly cover this on another webinar. So trust for specific beneficiaries. Let's talk about pets. We're going to lead with pets, okay? If you have pets, I hope you love your pets. I mean, we've got an old rescue dog. She just keeps living, she's healthy, slowing down. We love her to death. But in California, it used to be that you could only create trust for people. And that would be human beings with heartbeats. Okay, so living people, not dead people, or a charity or a corporation, partnership, or LLC until 2009. So fairly recently, I mean, a little while ago, 15 years ago, 16 years ago, pets can't enforce their rights. And here's kind of the fundamental idea is that who's going to enforce the right for the pet, right? Well, California said, let's create a structure where we can do that. So here's how a pet trust works. You can say, I'm going to leave assets. You could leave all your assets for your pets. I did have one client do that. Or you could leave 100,000 or 50,000 or whatever it is. When I pass away in my living trust, there is a sub-trust that is a pet trust. And what happens is we do have this trust administration. You're going to have to go through all the things that you need to go through, settling your affairs, paying your last illness expense, removing your name. Like if this is your trust, removing your name from the trust. And then the money goes into a trust, and that money is used for the pets. Now, Tina here in our example, Owen is the owner. Owen left everything to his dog and cat and Butterfly. And Tina, actually Butterfly is not a beneficiary. It must be a domestic animal. Tina is the trustee. Now, it's Tina's job to use the money to benefit the animals, okay? There is also a beneficiary after the animals because animals are living creatures and much like humans, they don't live forever. I guess giant tortoises live for a couple hundred years, but most animals have a shorter lifespan than humans. And so there is typically a human beneficiary, or you could have a charitable beneficiary after the dogs have passed away. There are some mechanisms in there to protect the dogs and the ultimate beneficiary. And the question is like, who can come in and say, hey, well, Tina's embezzling the money and not using, she's just leaving the dogs and cat to run around and she's really not taking care of them, there's a mechanism to enforce that. So that's a pet trust. All amounts must be used for the benefit of the animal, not the trustee. That's important. Otherwise, it's embezzlement. And at termination of the trust, the leftovers go to the pet trust. So in our example here, Owen's Living Trust contains a pet trust giving $50,000 to Tina as trustee for her to hold for the care of Rover. Tina must use the $50,000 for Rover's care, and when Rover dies, the leftovers go to Ben. Trusts for loved ones with special needs. So this is very important. We're going to talk about special needs trusts. If this is you or somebody you know that has a loved one with special needs, you know that you might have heard of this special needs trust. Well, what is it? Well, the idea here is people who have needs-based public assistance benefits who cannot own more than $2,000. If this sounds familiar, right? You can't have more than $2,000 in your account at the end of the month. What if you need to leave them money or want to leave them money, whether you're alive or after you pass away? So this is where we have what is called a third party special needs trust. So the beneficiary, this is the loved one with special needs, cannot have direct access to the trust or its money for things like food and shelter. Okay, you can't have direct access, and that money cannot be paid for food or shelter if they're receiving SSI, that's supplemental security income, which is a needs-based public assistance benefits that likely will kick them off of their eligibility. So very important. This can be used for education, medical, dental, hobbies, vacations, personal care and maintenance. It can be used for a lot of things, but it can't be used for food or shelter. Now, the nice thing about a special needs trust, other than a living trust, is this trust maintains the government benefit. So if you have a loved one with special needs and you have a normal living trust, now a living trust can say that when I die, this special needs trust is created inside of the trust. So that trust is not created until the person's death. Or you can create a standalone special needs trust. And that's where your living trust, you create a special needs trust that's current and valid as of today. But that may not receive money from your estate until you die. That could be 20 years from now, right? So you could set it up inside of your living trust where that activates when you die, or you can set up a current trust. The reason people set up a current trust is they either may be making a substantial gift there, they may be making annual gifts, they may be parking money there, but more commonly, other family members want to leave to that loved one with special needs. So if you set up a separate standalone special needs trust, those other loved ones with, those other people who care about your loved one with special needs can put money into that trust. So the key differences between a living trust and a special needs trust. A living trust allows you, the grantor, to retain control over your assets during your lifetime. And the primary purpose of the living trust is for estate distribution, for getting money from you to them, right? From you to the people you care about, and avoiding probate. Special needs trust has a different, sort of a different viewpoint. These can be revocable. They can start out revocable. By and large, they're going to be irrevocable. Now, what I mean by revocable is you could set up a trust that says this is a revocable trust, but once more than $19,000 gets put into this trust, it becomes irrevocable. That's because $19,000 is the gift tax exemption amount. So some people put a small amount in, but they don't necessarily want to, pay, file a gift tax return, right? If they're putting in $10,000 a year, this is, but most of these, I would say from the outset, are irrevocable, just broadly speaking, meaning you cannot amend it, you cannot change it. So you can modify here. Now, here's the other wrinkle on this. You can modify an irrevocable trust with consent of the parties. However, not only you have to get consent of the people who created the trust as well as the beneficiaries. If your beneficiary is not cognitively impaired, that may not be an issue. But if your beneficiary is cognitively impaired, that option may not be available. You might have to go to court. So the special needs trust focuses on maintaining eligibility for government benefits and caring for the loved one with special needs. But the real reason these are created what makes them different is their focus is on maintaining government eligibility. So let's look at a case study of Abel. Abel is 30 with developmental disability. He's on SSI, supplemental security income, and Medi-Cal. Abel's parents put $600,000 in, so they pass away. They leave $600,000 from their estate to Abel's special needs trust. And this includes proceeds of a life insurance policy and savings. And this is to be managed by a third-party professional trustee. So there are trustees out there whose profession it is to serve as trustee. And then there's a subset of those who really focus on special needs trusts. So, with a properly structured special needs trust, this is an irrevocable trust. Abel 600,000 can it can be kept in the trust, right? And he preserves his government benefits. Even after Abel's parents are gone, the trustee of the special needs trust can pay for computer, internet, online games, trips to Disneyland, transportation, maybe a personal care attendant, and provide structure to ensure that Abel is properly cared for. You can appoint a care manager or a committee inside of this trust. So you've got some guardrails on there to make sure that if you've got an Abel, that your Abel is protected. So two types of special needs trusts. I want to touch on this briefly. I would say there's a first party special trust and a third party trust. Most people, if they had their druthers, if they could choose, they would say, well, I want a third party trust because, first of all, this is funded with assets that aren't the loved one with special needs. It's not that person's assets. These are assets. Third party trust is those assets come from third parties, parents, friends, aunts and uncles, grandparents, siblings, whatever it is. This is very important because there is no reimbursement to the state. There's no reimbursement for Medi-Cal benefits. There's no reimbursement with a third party trust. With a first party trust, and this is fairly recent, that's where you may have, in our example, Abel, we saw this a lot with the PG&E settlements. A lot of people suffered an injury and they are on SSI, they're on disability. They suffered an injury related, whether it's property damage or personal injury to the fires in Northern California, and get a check for $100,000. That's going to kick you off of your public assistance benefits. So what you can do is have a friend or family member create a first party special needs trust and then put the money in there. So the problem is that whatever is left in that trust is available to pay back to the state. So if you have a first party and a third party, you're going to want to spend that money out of the first party special needs trust probably first. So I just want to cover the difference between a first and a third party. So pet trust, the beneficiary is going to be a pet. That's going to be the first beneficiary. And a special needs trust, it will be a loved one with disabilities. And this pet trust is a highly specific trust just for the care of animals. A special needs trust is critical, I think, for beneficiaries with special needs, certainly people who are on supplemental security income. And if you're watching this on YouTube, we've got some notes on that. So let's talk about revocable versus irrevocable trust. Remember, a revocable trust can be amended after funding the living trust. So you put assets in there. I'm leaving all to my 3 kids. And then I say, I don't like 2 of them. I'm leaving all the 1. I do an amendment. An irrevocable trust can't be amended. And remember, the irrevocable trust, some of the acronyms is sort of alphabet soup you might hear. A B trust, a bypass trust, the below ground spouse trust, Q-tip trust, inheritance protection trust, IRA legacy trust, dynasty trust, spendthrift trust, special needs trust. Those can be revocable, but generally they're irrevocable. But these are the types of trusts where you hear irrevocable. There's really kind of only one revocable trust we use, and that's the living trust, right? But again, that living trust can have that secret surprise in there where you might have some embedded irrevocable trusts when one spouse dies. So what is an irrevocable trust? An irrevocable trust is a legal arrangement where the person creating the trust, known as the grantor, you might hear the term settlor, you might hear the term trustor, you might hear the term trust maker. For our purposes, we'll talk grantor, transfers assets into the trust and gives up all rights to own that. Now, sometimes you give up rights of control. If you're creating an irrevocable trust for the benefit of your children, you have to be very mindful of the powers that you retain, right? If you're going to serve as trustee. Many people, and we'll talk about different types of trust, for many people or many situations, the person who creates the trust should not be the trustee, and neither should the spouse be a trustee. So we're going to talk about those different use cases. Other types of irrevocable trust, the person who creates the trust can be the trustee. It's permanent. Once it's established, the trust cannot be altered or revoked by amendment, by unilateral change of the grantor. Now, if you have consent to the beneficiaries and nobody's died, you can modify the terms of the trust by agreement. Okay, modify the terms of the trust by agreement. In a living trust situation where one spouse has died, you can't do that. At least I don't think you can do that. Other practitioners read the probate code differently. I think it's an erroneous view. I won't get into the details. Just remember, if you're talking about a spouse where one spouse has died and there's a survivor and you're stuck with the B trust, you're probably going to end up going to court to modify that trust so you eliminate that capital gains tax issue. Assets placed in irrevocable trust are generally protected from creditors and legal judgments. It can provide tax advantages, can reduce estate taxes, can provide a lot of things. And so let me go back here. So how do you dissolve an irrevocable trust? How to dissolve an irrevocable trust? So a lot of people think the term dissolving a trust when they say, okay, mom and dad died, how do we dissolve this thing and get everyone their money? A lawyer would never use that word. A lawyer would say, oh, that's trust administration. The problem with trust administration, nobody knows what it means. I listen to it. It's just such blah, blah, right? What does it mean? Really, what we are talking here is about dissolving a trust. It's probably a more appropriate word. It's crucial to involve an experienced attorney because, and frankly, and CPA, because you have a lot of complex legal and tax implications involved. So when you terminate a trust, when you end a trust, or when somebody dies, you have a lot of tax issues that are not just estate tax issues, and we cover this in other webinars, but it's very important. A lot's going on there. The attorney typically will look at the situation and identify if there are legal grounds for dissolution, meaning can this trust end or must this trust continue on for another generation? So it'll say in the trust whether it's possible to end. Irrevocable trusts are often used for more specific purposes like estate tax reduction, charitable planning, or special needs planning. So that means a misstep can have huge consequences. If you say, gee, mom and dad passed away and they set up the special needs trust for Abel, my brother who has special needs. I really just don't want to deal with this. I want to dissolve the trust and put the money in my pocket. You're probably not going to be able to do that, right? You're going to have to live with that special needs trust because that's there to provide protection for Abel. So some trusts are designed to exist beyond one generation, right? This would be a dynasty trust. That a lot of the lawyers call it a generation skipping trust, but some of these trusts are designed to continue on for multiple generations. So if you inherit in a dynasty trust and you have kids and that trust says for you to use the property for your lifetime and then whatever's left over go to your kids, if you go to the lawyer and say, I want to dissolve this trust and yank all the money out, you're not going to be able to do that without a court order. In fact, you may not even get a court order to do that. So it's very important. Certainly if they're minors, it would be more of an issue. And could be some significant negative tax consequences to that. So let's talk about types of trusts for wealth protection. We're going to give a 30,000-foot view. We're going to kind of run through a lot of these. So there's a dynasty trust. In simple terms, this builds a financial legacy that can last for many generations. So it protects money from estate taxes and creditors each from one generation to the next. This is a long-term commitment that locks up family wealth. Is it inaccessible? No, but this is something where this wealth is locked up for multiple generations potentially and not going into the pockets of the individual beneficiaries. Can they get a benefit? Yes. Has this been described as a family bank? Yes. So imagine if you had a dynasty trust that was essentially a lending facility that allowed you to borrow at low rates. Now, right now, those mandatory rates are hovering somewhere in the 4%, but wouldn't it be nice to borrow money interest only at 4% from a family bank instead of going out and getting a loan for 6.5%, right? So these are complex, they're expensive to set up and manage. The domestic asset protection trust, we like Nevada for this jurisdiction. It looks kind of like a personal safe for your assets. It shields them from future creditors or lawsuits. This is very important. There's also a seasoning period of 2 years for new money. So there's this 2-year window where if a creditor pops up in 2 years, slightly different rules. I would say it's a one-way street. Once the assets go in, you can't easily take them out. It's not like I'm worried about getting sued. I'm going to set up this domestic asset protection trust until the storm passes. No, this is a little bit longer commitment. It's only available in certain states, and you are free if you're a California resident, you're free to do a trust in a different state. The hitch is you're going to need to have a trustee resident of that state. And it's not going to be you. The irrevocable life insurance trust, it holds a life insurance policy so that payout is not includable in your estate. If you have a $50 million estate and a $10 million policy of life insurance, if that policy of life insurance is not included in your estate, when that $10 million pays out, $4 million, at least under current law, is paid in tax. If it is in an irrevocable life insurance trust, properly structured, you save that $4 million in tax. If you have a $5 million estate and you've made no gifts and you have $1 million life insurance policy inside of an irrevocable life insurance trust, it's not benefiting to keep it there in the sense of you might have done that a long time ago when the estate tax exemptions were lower, but you still have to live with this thing, right? And so if that's you, you could certainly call us and see if we could dissolve that trust or not. That's one we would take a look at. So irrevocable life insurance trust, you can't be trustee. You know, if it's on your life and you set up this irrevocable life insurance trust, you're prohibited from being trustee. So you have to have a third party trustee. The spousal lifetime access trust, this is where I could give my wife up to 13.99 million in a trust. That is not, there's no gift tax paid. That 13.99 million stays outside of both my estate and her estate at death. And that can go into a dynasty trust and grow and grow and grow so that when the kids inherit it, it is not included in our estates, thereby saving estate tax. Now, if a married couple has a $100 million estate and a spouse does a spousal lifetime access trust, that makes sense. If a couple has a $10 million estate, I'm not seeing the use case for it, except maybe potentially for creditor protection because there's no estate tax reason. Again, because the estate tax exemption's at 14 million. So this is going to be typically for larger estates, or if you think something might grow. So if you've invested, 25,000 into 10 startups, it's 250,000. You go, look, this thing could pop. I want to put those into a spousal lifetime access trust. That might not be a bad idea. So if it does pop, one of those $25,000 investments becomes 20 million. It's out of your estate for federal estate tax purposes. There's out there in the ether is the intentionally defective grantor trust. What is this? So it's not defective because it's wrong or it's bad. It's just that where I create an irrevocable trust, I put assets into this irrevocable trust. I'm still deemed the taxpayer. So let's say I put $10 million into a trust. Let's say I got a $100 million estate, which I don't have. I have a $100 million estate. I put 10 million into a trust and, or let's say I put 14 million in a trust. So I have 100 million to put 14 million in a trust and I sell the stock that's in the trust and it generates a $5 million tax bill. I'm stuck with that tax bill. So I pay that tax bill. My kids' trust, right, where I've transferred that 14 million does not pay the taxes. That is effectively a backdoor way of transferring more wealth to the children, okay? And as those assets generate capital gain and income tax liability over time, I'm paying that liability. This is a very powerful tool over time. If you're a wealthy family and want to reduce the value of your estate because you and your kids are probably going to pay taxes at the marginal rate anyway, it makes sense for you to pay those taxes and have those assets on the kids' side of the ledger. So I say these are complex, they're irrevocable. Qualified personal residence trust allows you to give a property to a child and not use as much of your gift tax exemption. You can give 19 million tax free. If you give more, $19,000 in any given year without having to file a gift tax return. If you give more than 19,000, you have to file a gift tax return. If you give more than 14,009,000, so 13.99 million plus 19,000, then estate tax is due. So we're going to have an example of a QPERT in a little bit. And then a charitable remainder trust. It's also called a split interest trust. It's where you create an irrevocable trust. You put assets into this irrevocable trust. You get some benefit back. You can get up to 90% back. Minimum 10% has to go to charity. You get a current income tax deduction, but a portion's going to the charity, a portion's coming back to you. We'll talk about that. So advanced wealth protection and transfer strategies, the dynasty trust. What is the dynasty trust? It's a trustee controls the keys to the dynasty trust, treasure trust. Think of it as a locked box, right? In each generation, the assets will hopefully they'll grow, but the key to the treasure chest is always held by a responsible trustee, not the people who are the beneficiaries. Now, could you be a beneficiary and be a trustee of this dynasty trust? Yes. But the idea here is you have the trustee has control. The beneficiary gets the economic benefit. That trust can dispense funds. It is a more common structure to lend money to a beneficiary, because then that keeps the beneficiary's estate small because you've loaded it up with debt from the dynasty trust. So that's just one mechanism. I'm giving you just a little bird's eye view here on what a dynasty trust is, but this is a very powerful tool. Once transferred, the estates, the assets belong to the trust and not the estate. No estate taxes are due as this money transfers from generation to generation. This used to be not that big of a deal when our exemption was $1 million. Now at 14 million, a lot more people are looking at this because it's potentially a lot more value. Generation skipping transfer tax is very important to understand. Generation skipping transfer tax is not an issue for in 2023 if you're transferring less than 12.92 million, but now it's 13.99 million. That 12.92 million's grown. So in 2025, grandma leaves 23.99 million to her grandson. So it's a direct skip. The first 13.99 million passes free of tax. The remaining 10 million is taxed at 40%. So that leaves 6 million. That remaining 6 million is taxed again at 40%. So the total tax bill is 6.4 million on that 10. If it had gone to the kid, the child, so the grandson's parent, you would have had not 6.4 million in tax, but 4 million in tax. So an extra 2.4 million because you're skipping a generation. That's what generation skipping transfer tax is, tax twice. If a dynasty trust is properly funded, you avoid this. Okay, it's very important. Domestic Asset Protection Trust. What is it? It's a type of trust designed to offer creditor protection and can be structured to allow discretionary distributions. Nevada is a great state to do it in. Nevada requires a creditor to challenge a transfer within 2 years of the transfer date or within 6 months of discovering the transfer. So a little bit of, there's some rules in there, so there's this 2-year window, but after that, the creditor can't come forward. Now, if you have an existing creditor, you say, yeah, I'm in the middle of a lawsuit, you can carve out and say this plan does not apply to that particular lawsuit. So John, a successful entrepreneur, creates a Nevada Domestic Asset Protection Trust to safeguard his wealth from potential business liabilities. John transfers $2 million into the trust, naming himself and his children as beneficiaries. The trust appoints a Nevada trustee to manage the assets. 2 years later, John's business faces a lawsuit, but the trust assets remain protected. Meanwhile, John can receive a discretionary distribution of $50,000 annually from the trust, which the trustee approves for his living expenses. Now, that $50,000 that's distributed is available to the creditors. Okay, you need to understand that. But this allows John to benefit from his assets while shielding them from his creditor claims. The Irrevocable Life Insurance Trust. Life insurance is free from income tax. Life insurance is also included in an estate. And if Wanda has $1 million death benefit, when Wanda dies, the $1 million life insurance is subject to the 40% death tax, right? That's $400,000 on $1 million. Now I'm assuming Wanda has maybe a $15 million estate, right? And has $1 million. Because if you have a $5 million estate and $1 million life insurance policy, there's no tax because you're under the 13.99 million. So this really hits people who are wealthier. So what can Wanda do? Wanda creates an irrevocable life insurance trust. Somebody else is trustee. Wanda makes a gift of annual premium, $19,000. Pays that premium is paid to the trustee. Uses that money for to pay to the life insurance company. Wanda dies. Those funds come into the irrevocable life insurance trust and are outside of her estate. So there is also a second to die for couples. Second to die. So if, let's say we have Hal and Wanda, they're married. They get a second to die policy, which pays out on the death of the survivor of the two of them. This tends to cost less money, is the bottom line. So if you're insuring two people, typically the cost of insurance is less. The estate taxes typically hit on the death of the surviving spouse anyway. So this is aligned. The payment of the life insurance is aligned for when the taxes would be due. And a lot of times these life insurance trusts are, frankly, they're used as a pot of money to pay tax. Really what you do is the life insurance trust buys assets from the estate and the estate pays the tax. That's really how it works. With a proper irrevocable life insurance trust, Hal and Wanda can put their joint or their survivorship policy inside that life insurance trust and avoid estate inclusion. Benefits of a life insurance trust: it removes insurance proceeds from your taxable estate. You put money into a trust and the trustee takes the money out of the trust bank account, pays the premium. Upon your death, this passes to the beneficiaries free of income tax, free of estate tax, but you give up all control. This is very, very important. You're giving up all control. You can't be trustee. That money goes into the black box and you're not seeing it again. And of course, that insurance pays out after you're dead. So you're not going to see it. The spousal lifetime access trust. Spousal lifetime access trust. Another way that wealthy people um, use irrevocable trusts to build wealth, to protect their wealth from creditors, and protect their wealth from being taxed when they die. So this is the gifting spouse or the grantor creates a spousal lifetime access trust. And this can include cash, can include life insurance, real estate, businesses, other assets, kind of whatever you want to put in there. The spouse is the beneficiary. So I create it for my wife. That's not my money anymore. I can't be trustee. I can't get any benefit from that trust. Honey, I love you very much. Here's 13.99 million. Oh, she says, thank you, right? She's the beneficiary of this trust. And when she dies, the kids are the beneficiary. That's how a spousal lifetime access trust works, right? It's also called a lifetime bypass trust. You might have heard of that, but it's funded by this completed gift. I cannot retain the right to leave it to somebody else, right? It's forever locked in. This is established by one spouse, the donor spouse, for the other spouse, the donee spouse. The remainder typically goes to the children. It can go anywhere. It's a good way to use your $13.99 million exemption amount, and this can reduce substantial amounts of appreciation from the gross estate and still have access, right? Still have that spousal access. So good for a lot of people. I think it's appealing to those who people who want to lock in their high estate tax exemption while retaining, while the spouse retains some access to the money. Beneficiary can receive distributions only when necessary, or liberal, conservative. A lot of times that's the last money you're gonna withdraw because it is in this sort of estate tax free zone. And contributions can be complete or incomplete. What do I mean by that? You could have an incomplete spousal lifetime access trust. If I create an irrevocable trust and I retain the power to leave that property to somebody else, either during my lifetime or after death, that is called a retained limited power of appointment. That makes the gift incomplete because I still have some incidents of control. So we can see this a little bit with creditor protection, although we don't really see incomplete spousal lifetime access trust much in California, because one of the reasons that people do them, right? Not only is there a fair amount of creditor protection, not only not included in your estate at death, but a lot of times you can defer the payment of California state income tax, including capital gains on assets. So if your spousal lifetime access trust is cited in Nevada and does not have California source income assets, meaning it has publicly traded securities in companies, Apple, Google, Nvidia, whatever you want to put in there, while those dividends are being paid, while the stock sales are happening and dividend reinvestment, there is no California income tax paid unless and until money is distributed to or for the benefit of the donee spouse. Let me say this another way. I create a spousal lifetime access trust cited in Nevada with the Nevada trustee. I put $14 million of a stock portfolio in there. It's generating income, capital gains. It's actively managed by a money manager. We're paying federal tax, but there's no state income tax paid until my wife, until the trustee pays her Amex card, right? Or the trustee distributes her $100,000. That's when you see the California state income tax issue come up. So it's fundamentally a deferral strategy. It's not an avoidance strategy, unless, of course, when that money is distributed to the spouse, she's not a resident of California. Then California, they're going to be out of luck. So Able creates a spousal lifetime access trust under Nevada law. Puts in 2024 put 13.61 million in. So this was last year. The beneficiaries are Abel's spouse Baker and their 3 children, Charlie, Delta, and Echo, and a common trust. So the 4 of them are beneficiaries, while Abel and Baker are living. So Abel creates a trust for Baker. When Abel and Baker die, the property goes to the 3 kids. Property passes free of estate and death taxes, even though it may have grown to $50 million, right? Abel saves the family millions in death taxes due 9 months after Abel and Baker's death. Now, in 2025, Baker, who is Abel's spouse, creates a Wyoming dynasty trust, goes to a different state, maybe goes to a different law firm, puts $13.99 million into a trust for the benefit of Abel and Baker's 3 children. So Abel's not a beneficiary. When Baker dies, so you have Abel and Baker, Abel's still alive, Baker dies, Abel becomes a beneficiary with Charlie, Delta, and Echo in a common trust. So it sounds a little bit like, remember in 2024, when Abel created a spousal lifetime access trust, Baker and the three kids were beneficiaries. Well, here, once Baker creates a trust and once Baker dies, Abel is a beneficiary. So Abel is going to be a beneficiary um, of the trust, right? So when Abel and Baker die, it goes to the kids. This gets this property passes free of estate and death taxes, even though it's grown. Baker saves the family millions of dollars, both Abel and Baker. Now, what we're trying to avoid here is the reciprocal trust doctrine. If Abel and Baker sign trusts where Abel says, "Oh, Baker, I'll give you 14 million," and Baker says, "Abel, I'll give you 14 million," the IRS says, "Nice try. We're going to just collapse all of that under what is called the step transaction doctrine or reciprocal trust doctrine." And you can't do it. So these trusts have to be different. They should be created at different times, and they can't be part of a comprehensive plan to do this. These have to be independent actors. So just giving you a high level on the nuance of slats for couples. The intentionally defective grantor trust, what is it? It can gradually reduce the value of your estate. So if it's my estate and I set up an intentionally defective grantor trust, I put assets into it, there is something called tax burn. Every year, I'm paying the tax on assets that I've given away. That reduces the value of my estate. That increases the value of my kids' trust. Over time, used in combination with other strategies, this can be extremely powerful. And when you model this out on a spreadsheet, it can be very surprising. You go out 20, 30 years, it can be a significant wealth transfer. Gifts up to $19,000 per person per year can go in tax-free. And assets transferred can't be retrieved or pulled back. If you've given the asset away, you can't bring it back. That's very, very important. So we have a graphic here where the grantor transfers assets and the income is reported on the grantor's trust. This is the tax burn effect. There are a lot of other uses for the intentionally defective grantor trust, but I do want to cover this because a lot of people, if you watch this and you go, "Yeah, I got one of these. I did it 10 years ago. This really stinks because I'm stuck with the taxes. I have to pay the taxes." You can write into the trust that if the grantor tires of paying the taxes, that trust has the ability to reimburse the grantor for those taxes. You cannot add that. There's a very recent IRS ruling. You can't add that to a trust, but certainly you can create it from the get-go. So older trusts didn't have it. So how does an intentionally defective grantor trust work? It allows you to transfer using discounted valuation. So if you have, we've done this with clients. We create a holding company that holds real estate assets. And if you give 10% of that, and maybe 10% of that, you give 40%, let's say 40% has a value of $21 million, you can compress that value because if you give somebody something that they can't sell and you give somebody something that's a fractional interest, I'm giving you a 40% interest in this pen, it's not worth 40% of the pen, it's worth less. And this is what is taxed is the thing that is transferred, okay? Not the whole value, the proportionate value, but it's the thing that's transferred. So stated another way, you can make a gift of certain assets and the government says, even though if you liquidated everything and everyone took the cash, this kid would get 21 million, we're going to tax it as if it's 13.99 million. That concept is called discounts for lack of marketability and control. It works in the real world. You can move, in this case, 21 million bucks, free of tax, and that can grow to a bigger number. And the person who created the trust, the grantor, can pay the tax. So this is very good for high net worth people. Qualified personal residence trust it gives you the ability to make a gift of your home in an irrevocable trust where you retain the ability to live in the home for, say, 10 years. And then at the end of that 10-year term, the property becomes your kids' property. Let's assume your kids, right? Or other people. Your kids are now the owners of that property, basically, and then you can rent from them. Now, people would say, there's no way I'm giving away my house, number one. And secondly, there's no way I'm giving away my house and paying rent. Are you kidding? This is what wealthy people do to minimize their estate. So you can give a $10 million house and the value of the gift may only be $4 million. Your right to live in the house is $6 million. At the end of that term of that Cupid, could be 20 years. The kids get a $20 million house, but they've only been taxed at 4. And now you have to pay rent, which is further depleting your estate. There's no income tax on that rent because we use a grantor trust, one of those idiots. But it's very important to understand that when you do this, you are giving up the underlying ownership of your home, and you will be renting ideally in your older years. So this isn't for everyone. A lot of people have taxable estates. I would say most people with taxable estates end up doing this. When you see the term qualified in anything under law, it means there are special rules under the Internal Revenue Code. Qualified should be a trigger for you. Anything that's a qualified plan, an IRA, 401k, 403b, TSA, a qualified personal residence trust, a qualified annuity, that means that it has special treatment under the Internal Revenue Code. And normally you can't do this, but there's a carve out. You normally can't give something away and keep using it, but they do have a carve out for personal use assets, a home and a vacation home. So this is the example. An example here is Hal transfers his home to a Cupid, retains the right to live rent free for 10 years. When the 10 years is up, Hal must start paying rent. And the property's reassessed after that 10-year mark, right? And so these are some things that you need to go through with your attorney. Don't just jump into this willy-nilly. It's not something you want to download a form off the internet and go for it. Not a good idea. The charitable remainder unit trust, will finish with this strategy. A charitable remainder unit trust is a very interesting, what we call split interest gift. So what this is a person puts something of value in the trust. This is before you sign your purchase agreement. You can't be like in escrow and be, hey, my 1031 fell through. Can I do one of these charitable trusts? You have to set this up before you sell like real estate, okay? This is where you create an irrevocable trust. You can retain up to 90% of the value of the asset, and whatever is you don't retain, your family, whatever, goes to charity. So a minimum 5% has to go to charity. What people do is they might have a house, and I think we have an example in here of how to do this, but you transfer assets to a trust, you sell that does not immediately trigger capital gains. So if you bought some stock for $1 a share and it's $100 a share and you put that in your charitable trust, you sell that stock, you're not paying capital gains tax right away. Now, as you are distributed money, you're paying capital gains tax. So for many people, this is fundamentally a tax deferral strategy. So the money that would have otherwise been paid in tax is in that trust working for you. And when those payments come back, they're going to be subject to potentially income tax, capital gains tax. If it's a return of what you put in, that would be your basis, your principal. You can think of it that way. You're not taxed on that. So it's fairly complex in terms of the tax compliance. You have to pay attention to a lot of numbers. But let's look at this testamentary charitable remainder unit trust in the context of an IRA. So under current law, if your beneficiary is not an eligible designated beneficiary, typically someone who's disabled or a minor, let's say you have $1 million IRA, you leave that IRA, it's not a Roth, you leave it to your kids. They might not have to take money out for 10 years, but in 10 years, they're going to have to take out $1 million. They're going to have to pay half in tax. Well, that million might have grown to 2 million, right? But with this charitable trust, 5% has to be paid out. What this is when you die, your IRA goes to a charitable trust. You have up to 20 years, right? Or your heirs have up to 20 years. Maybe your kids have up to 20 years to stretch this IRA out. And when you plug in the numbers, your family may end up with more money, stretching out the taxation of this IRA, right? Compound interest, right? They make more money because the tax is deferred for a longer period of time. Even though the charity is getting 5%, your family may end up with more money. Interesting. So that is a testamentary charitable remainder unit trust. And here's a tax deferral strategy. So you've got a highly appreciated asset, stock, real estate, crypto, business interest, whatever you got. Selling it now would trigger a massive capital gain. You fund I'm going to just pick 10 years out of a hat. You fund a 10-year term charitable remainder unit trust. So this is how it works. Step one, you set up the charitable remainder unit trust, transfer the asset in, then the charitable trust sells the asset. There's no immediate capital gains like there normally would be if you sold the asset. You have capital gain for that year. You receive annual income for 10 years. It has to be a minimum 5%, maximum 50%. At the end of the 10-year term, the remainder goes to charity. If you put $1 million in and you took out $100,000 a year for 10 years, You might not have any federal capital gains tax if you don't have other income. So if you're 60 and you say, I'm over concentrated in the stock position, if I sell that $1 million position, I will pay 350,000 in capital gains tax, and I'm not working. I'm not taking money out of RMDs. I'm living off savings and I'm driving around in my Sprinter van looking at, the United States and Canada. This may be something good to explore, because you could take that $1 million position, put it into a charitable remainder unit trust, allocate to different stocks, maybe a more balanced portfolio, and take 10% out a year. That 10% out a year is 100 grand a year. If you're married filing jointly and have no other income, you're not paying federal capital gains tax on the first $94,000 in income. So these are the type of strategies when you hire a law firm that pays attention to tax. This is what you'll be getting, or this is what you should be getting. I will tell you, most estate planning attorneys have no idea what I'm talking about. Okay. This could be a very predictable cash flow stream for you if you set this structure up. The charitable deduction, you're going to get a partial deduction up front and support a cause you care about. This is irrevocable. There are no take backs. You can't put it in and 3 years later say, hey, I want all my money out. The charity has to benefit at least 10%. And remember, it's gone. What's left after 10 years, whatever's in there goes to charity. So this brings us to the end of our materials here. We have offices throughout Northern and Southern California. If you're watching this on YouTube, please subscribe to our YouTube channel, and we will open it up for questions. If you're watching this on YouTube, if you've made it this far, keep watching. Another video is going to roll right after this one. And if you would like to see the questions, by the way, if you have questions, post them on the YouTube Q&A. But if you would like to hear these live, come to one of our webinars. You can sign up on our YouTube page, you can sign up on our webpage, and the link will be in the materials. So thanks for joining us.